first case for the morning is State v. Khalfani. Each part will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. Do you know how long you'd like to reserve, counsel?
Thank you, Your Honor. May I please, I'd like to reserve 5 minutes for rebuttal.
All right, very good. So if you're looking over there when that first one down to 10 or 5, that when your time will be up, we're not resetting the initial 15 minutes. The arguments are being recorded. When you present your argument, please introduce yourself. Keep your voice up or remain behind the podium. You should not use the name of any child, minor, or victim during the argument. You can use initials or something like that to refer to them as you will. The judges have read your brief and are ready to proceed whenever you are.
Thank you, Your Honors. May it please the Court. My name is Attorney Wesley Buchanan. I have the privilege of representing Osiris Khalfani, the appellant in this matter. Just by way of a brief overview, this is a reopened appeal. Osiris had a bench trial, was convicted of murder and a 3-year gun specification. On his direct appeal, appellate counsel raised one issue of sufficiency of the evidence. This court affirmed his conviction based upon that appeal and cited 2023 Ohio 1963 State v. Khalfani as his direct appeal. Osiris then pro se reopened it and asked this court to reopen it, and that's how we got involved. So at the outset, Osiris is noting that all of the arguments that he's making are under the prong of the Strickland ineffective assistance of appellate counsel, where Osiris has to demonstrate that the deficiency of appellate counsel was there, and then but for that deficiency, this court would have reversed his convictions. So that's the overarching theme for Osiris's case. Osiris can indicate to the court that the deficiency prong should have been met in a sense. This was a murder trial. There was a full trial, and even though it was a bench trial, there still was a trial. So typically in a trial, you will have various different evidentiary issues, sufficiency, manifest weight, and all of those, and jury instructions, juror voir dire, those kinds of things, for this court to review on a direct appeal. This court, through its staff and through many CLE teachings, has always indicated that this court wants to hear the argument, and the arguments that need to be raised, even if not frivolous arguments, even though they may not be winning arguments. So as far as a murder case is concerned, again, Osiris is a young man. He's looking at 28. He's got a sentence of 28 years to life. So it would be due process to take a little bit of time to review his case. So if that's said, in addition, Osiris will also note this was a bench trial. So this court can presume that the trial court followed the law and ignored any extraneous, irrelevant, or prejudicial information. That's the presumption that this court has to make. In addition, Osiris took the stand in his own defense. And so Osiris understands that while you do take the stand in your own defense, the trier of fact can believe all, some, or none of the testimony, because the person who is accused, who takes the stand in their own defense, their credibility is weighed just like every other witness. And that's part of the instruction that Osiris has to note. So as far as the arguments for Osiris, the but-for prong of the Strickland test, it would be the sufficiency and weight. Mostly this was a circumstantial case. There was video of the killing that was presented at trial. There was no DNA, no fingerprints, and no firearm ever recovered in this case. This court did note that on its direct appeal. In addition, video probably inconclusive at best, and so that goes to the no prior calculation design. I mean, there was no evidence that Osiris and the decedent knew each other. There was no evidence presented that there was any phone calls exchanged between the two. The government's theory was that this was a murder for hire plot. And so in exchange for $9,700, Osiris was willing to commit this act. And so as far as the evidence that supports that, there was no evidence of prior calculation design, which is what an aggravated murder case is. And that's how it was indicted. In addition, the shoe size that was found was different than what Osiris testified that he wore. In addition, as far as the cell phone data that was also recovered, it is interesting to note that the government failed to meet its burden of production, which is a manifest weight argument, because the government never produced the cell phone call or the data that the decedent was on during this incident. The video demonstrates that he was on the cell phone within 1 minute of the act. And so that evidence was not presented at trial, and thus Osiris would indicate that the government, under a manifest weight theory, didn't meet their burden of production. Because if you were on the phone and it's the last minute of your life, there's reason to believe that that phone call is relevant and that information is relevant to anybody who's accused of that killing. In addition, the cell phone data taken from Osiris's phone indicated in the transcripts at page 173 the huge swath of land from Rolling Acres Mall from the west, from West Wilbeth to South Main to Good Park Golf Course. All of those locations are south and west of the address for where the killing allegedly took place. The address is in the transcripts. I won't cite that here in the oral arguments because it is part of the record nonetheless. So, and again, the money, the $9,700 in this case as well, there was no tracing of that money as well. Osiris presented evidence that that money was taken from his girlfriend's student loan money and from savings and from unemployment checks. And that was all that Osiris testified to. So as far as that is concerned, the sufficiency and manifest, those go to manifest weight and persuasion, indicating that Osiris should have a new trial. In addition, after the act, because Osiris' cell phone was taken, there was no communication from Osiris to any third party. In the government's theory of a murder for hire plot, the person who's hiring the assassin usually wants to know that the job is done. There is no evidence in the record or supports any evidence in the record that Osiris made any attempt to phone call, text, or any other communication to any other third party to indicate that A, the act had been complete or the deed had been done. And so the evidence in that situation demonstrates, as far as a manifest weight theory, because this court under a sufficiency theory has to take the evidence in a light most favorable to the government, whereas a manifest weight is a persuasion, and this court considers a 13th juror. So as far as the evidence against Osiris was concerned in his bench trial, Osiris would submit that appellate counsel was ineffective for not raising the manifest weights, or there was sufficiency raised, and but for that deficiency, this court would have reversed this conviction, and that would lead to the conclusion that his original appellate counsel was ineffective. In addition, Osiris wanted to note for the court about his post-arrest silence. That was listed in transcript on 366.
Counsel, so your argument really is, you've talked a lot about sufficiency and manifest weight, but your argument is on manifest weight, right? That the weight of the evidence...
I'm sorry, Your Honor, I didn't want to interrupt. I'll listen for the question.
That the weight of the evidence weighed in was not properly weighed in the outcome of the trial.
Correct, because in a sufficiency argument, the government gets the benefit of any inference gets to go to them. And so, again, in a circumstantial case, all those inferences go in their favor. However, in a manifest weight argument, it's the persuasion, the burden of production.
Sure.
And because there's a video of the incident and it was admitted to evidence, it's not in dispute that the deceit was on phone. And given this was a killing, a murder case, that phone call was important. So as far as the burden of production is concerned, Osiris does have to note that his key fob and debit card were found in a wooded area near the address. Osiris, when he took the stand, explained that he had lent a third party his vehicle, which leads to one of Osiris's arguments is because the trial court in the transcript, which is cited, I don't want to say admonished Osiris, but again, sarcasm and inflection of the voice are not reflected in the transcript, but the trial court asked, in essence, are you expecting me to believe this? And that's what the trial court asked. And so Osiris believes that because of that comment, the trial court may have been biased in the government's favor and not given a fair shake at the trial.
So you're saying in the middle of the trial, the judge questioned the credibility, inferred that she didn't believe he was credible?
Correct. Correct, and that was that exact site was in our brief, and I will get that for you, Your Honor. And that's exactly what the trial court asked the question, and it was, again, in the transcripts, we don't have inflection. And so the inflection is, you can't put sarcasm in a transcript, and so that's another issue as far as that is concerned. That's transcript at 380, is where the trial court says, quote, so your testimony today and what you want me to believe is that third party, who was a friend of another person, a friend of a friend, when you handed him the key fob, you also handed him your bank card, question mark. That's what you want me to believe. And that's transcript at 380. So the trial court asked that to Osiris during his testimony.
You have a minute left, counsel, please go.
Did the judge say anything else? I thought there was something about, in the briefs about, that the judge is saying that it doesn't separate easily, or, is there anything else the judge says besides this statement?
Based upon my recollection of the record, no, and that's Osiris' concern, because obviously he was on the stand and he felt that. With that being said,
Counsel, but isn't it a little bit different to say, is that's what you want me to believe versus you expect me to believe that?
those are different statements,
In different
absolutely.
words.
Those are different statements and different words, yes.
Do you think it's ineffective though for the defense counsel not to say something like, let the record reflect that that was a sarcastic statement?
And that's, again, that would be something that would have needed to be raised on Osiris's direct appeal. However, that was not raised on direct appeal, so that this court would have to find that plain error. And so that's the issue. And so first Osiris has to get the ineffective appellate counsel to then, how do you have ineffective trial counsel? So it's like a double prong. I'm running into my time for rebuttal, and unless the panel has any other questions, I will reserve the balance of my time for rebuttal.
Seeing none, thank you.
Thank you.
Please the court, Heather T. Martino on behalf of the state of Ohio, the appellee, we are asking this court to affirm the appellant's conviction for aggravated murder with a firearm specification. The state would submit that appellate counsel was not ineffective because the arguments that were asserted here in the reopened appeal do not have any merit. With regard to the sufficiency and weight arguments that were asserted here, they really go to the issue of prior calculation and design. There is no bright line test for prior calculation and design. While it's true that the Supreme Court has articulated 3 factors that you can look at to determine prior calculation and design, they are not dispositive, and they certainly do not apply to every case where there's prior calculation and design. But the 3 factors that were articulated in the appellant's brief and were articulated by the Ohio Supreme Court is to consider first whether the victim and the defendant knew each other. Second, if there was any thought or preparation that was given as far as the weapon and the murder site. And then, was the incident drawn out or was it instantaneous? Here, there was clearly thought that was given to the location of the murder and the murder weapon that was used. The evidence that was presented through video camera surveillance shows that the Charger that is registered to the defendant was parked about 150 yards behind the decedent's home. The individual that was driving the Charger exited the Charger wearing black sweatpants with the white stripe. About 4 minutes later, he comes back through the woods, goes back into the woods. The state submits that he was looking for something, specifically the key fob with the detachable holder that had Mr. Khalfani's debit card in it, and then the Charger leaves. In the meantime, video surveillance picks up during that 4 minutes that an individual wearing the same black pants and white stripe approaches the decedent from behind, fires the weapon, 7 hollow point bullets that are in the decedent, other casings that are found at the scene, and eventually they are able to find that the Charger is registered to Mr. Khalfani. They find that he lives in Columbus. When they get to his home, they find a gun, not a gun, they find $9,757.30 grams of marijuana in a popcorn tin, pants that match what the perpetrator was wearing in the trash, as well as shoes that have the same sole. So that would be the evidence to show that there was prior calculation and design. It supports at least 2 of the 3 factors, that consideration was given into where the murder was going to occur, into the weapon that was going to be used, and it was instantaneous. Mr. Khalfani, which the state respectfully submits was the shooter, knew where the decedent was going to be, immediately fired the gun, causing his death. That would be sufficient evidence, and the weight of the evidence, to show that there was prior calculation and design. With regard to the post-arrest silence, the evidence shows that while Mr. Khalfani was giving his version of events, explaining where the money came from, the prosecutor cross-examined him and basically said, when you talked to the police, you mentioned some of this, but not all of this. So they weren't commenting on the post-arrest silence, they were inquiring further into the version of events that he was giving to explain why he had almost $10,000 hidden in a popcorn tin in his apartment, along with 30 grams of marijuana. Even if that was error, it would be harmless error here. As appellant counsel pointed out, this was a bench trial. It's presumed that the court would follow the law and ignore any extraneous evidence or something that should not have come in that did come in. With
Were there
regard,
any other comments on the record from the prosecutor commenting about the silence of the defendant, at least talking to Mr. Morris or Detective Morris?
No.
This was the only one that you're aware of in the
that's
record?
the only one that I'm aware of, correct. With regard to the bias, though, when you're talking about comments in the record, the rest of that comment that the court made was basically, I'm just gonna put it back up so I say it correctly, but the court did comment on the fact that the key fob could easily be removed. The court said, so I looked at the key fob and how it attach it. It's very easy. So your testimony today and what you want me to believe is that the one person who was a friend of the other person, a friend of a friend, when you handed them the key fob, you also handed him your bank card. That's what you want me to believe. It can easily detach. I just looked at it. And that's on 379 to 380. That does not indicate any bias. That indicates a comment with regard to the credibility of the appellant's statement and the court's looking at the evidence and commenting on the evidence. So the state would respectfully submit that there's no evidence in the record of bias. Certainly that is something that is presumed that courts are not biased, and the appellant would have the burden of overcoming that bias, and that single comment based on a statement, self-serving statement that was made on direct is not enough to overcome that bias. With regard to the argument about restitution, the record shows that the parties agreed that the restitution would be paid in the amount that was left over from, the fine, it's not a restitution, I apologize for that. The restitution, I'm gonna say it again, I don't know why. The fine would come out of whatever was left from the court costs. So there was $9,757 that was confiscated. Mr. Khalfani and the state agreed that all of that money would be not returning to Mr. Khalfani. It would go to court costs, and the balance would go towards the fine. Mr. Khalfani does not dispute that there was a fine that was appropriate, and the record shows in the sentencing transcript of page 38 to 39, he agreed that that would be how it was going to be divided up. So based on that, there would be no error for appellate counsel to not raise that in the first appeal. Therefore, that is not going to meet the burden for showing that appellate counsel is ineffective. Therefore, there is no ineffective assistance of appellate counsel. The state would respectfully submit that all of the assignments of error lack merit, and Mr. Khalfani's conviction for aggravated murder should be affirmed. If there are no other questions, I rest my brief.
Thank you, Your Honors. May it please the court. As far as the rebuttal is concerned, Osiris would again indicate that the court has to issue a fine as far as an amount is concerned. That's what the statute requires, even if there's an agreement. However, that was not occurred here. In addition, that Osiris did present evidence that the monies that were there were not the result of this case. So, as far as the evidence was concerned, that's what Osiris would at least submit to this court, that the $9,700, the court does have the ability to fine Osiris, and Osiris did have retained counsel at the trial court level as well. So the trial court could certainly have made those findings, should have, but I don't believe they made the correct findings under 292902. So again, Osiris is asking this court to first thank the court for reopening his appeal. Second, find that the appellate counsel was ineffective, finding that the performance was deficient, and that but for the errors that were raised, the outcome would have been given. And that at the very minimum, issue a new trial order for Osiris. If this court finds that the evidence was sufficient to convict him, Osiris would ask that this court remand for a new trial, even though the manifest weight did not carry the day. And if the panel does not have any other questions, Osiris thanks the panel for their time.
Counsel, I would like for you to, if you would, share anything you have to say in rebuttal to the government's presentation about the post-arrest silence issue.
Correct. And again, Osiris's trial counsel asked questions to follow up immediately after those questions were asked as well. So there is an argument that it could have been waived. and then it could have been plain error, and that's why we would indicate to the court that that's something that Osiris wanted this court to know, and that's one of the issues that Osiris had in his many pleadings with this court. So that's what Osiris would like this court to do, is address those concerns. Does that make sense, Your Honor?
Will that answer your question? I'm sorry. Prosecutor seems to suggest, at least in their briefing today, that really this wasn't commenting on post-arrest silence, it was just trying to differentiate between the different comments that were made and cross-examine him on his inconsistency in his statements.
Sure, and so as far as post-arrest silence is concerned, you have the right to remain silent. So if I don't tell the police anything, then by nature the story's going to be different. It's always going to be an inconsistent statement.
Well, was this an attempt to say you told, I think with Officer Beach, whoever you met in Columbus, you told him X, and now your trial telling us why? And why are those statements inconsistent? Without necessarily saying you should have commented before, because he did speak to the police.
He did speak to the police, however, he did not provide the entire story. And when Osiris took the stand in his own defense, he said that he wasn't asked those questions. So Osiris pointed those inconsistencies, not that I was inconsistent, it's that the police never asked me those questions. For instance, there were questions about the money and everything else like that the detective did ask Osiris, and he did answer those questions. So the silence part is that, for Paul Harvey, this is the other side of the story, right? This is the rest of the story. And so as far as Osiris was concerned, because they didn't ask that question, he was silent. And that would be the position that Osiris would take. Does that answer the question, Your Honor?
It does.
And with that, again, Osiris thanks the panel. Thank you.
Thank you. The court will take the matter under advisement. The court will take, I want to also thank you both today for your presentation. The clerk will mail a copy of the decision to you on the day it's released and also be available on the high.